The flashing red and blue lights in my rearview mirror caught my attention as I was hauling a 50-pound bag of rock salt from my truck to the barn, and I honestly thought someone had gotten hurt on the main road. I'm Keith Morrison, and I've owned the Double M Ranch here in Montana, just outside Billings, for going on 15 years now. My property stretches across 1,200 acres of prime grazing land, purchased from my grandfather's estate back in 2010, when I was barely 30 years old. What I didn't know that cold February morning was that those police lights were actually for me, and the complaint that brought them here would unravel a legal mess that had been brewing since before I ever signed the deed. The officer stepped out of his vehicle, a young guy named Patterson who I'd seen around town a few times. He looked uncomfortable, shifting his weight from one foot to another as he approached. I set down the salt bag and wiped my hands on my jeans, wondering what on earth could be the problem. "Morning, Keith," Officer Patterson said, his breath forming clouds in the freezing air. "I'm sorry to bother you, but I've got a complaint I need to follow up on." "A complaint? About what?" He pulled out a small notebook, flipping through pages that fluttered in the wind. "Says here you've been spreading hazardous materials on public property without permission. Environmental hazard," the caller said. "Lady named Brenda Kimball from the Sunset Meadows HOA." I stood there for a moment, genuinely confused. Sunset Meadows? That development is 3 miles down the road. I've never even been to their neighborhood. And hazardous materials? I'm spreading rock salt on my driveway because we had an ice storm 2 days ago. Patterson scratched his head, looking at his notes again. She was pretty insistent. "Said you were contaminating their water supply and violating HOA regulations. She filed a formal complaint with the city and demanded we come out here immediately." "HOA regulations?" I couldn't help but laugh. "Officer, I own a ranch. I'm not part of any HOA. I've got 1,200 acres here, and the nearest neighbor is half a mile away. How could I possibly be violating their rules?" The officer seemed to realize how ridiculous this was. "Look, I agree this sounds off, but I have to document that I came out here. Mind if I take a quick look at what you're doing?" I gestured toward the bag of rock salt in my driveway, which wound from the main barn up to my house about 300 yards away. "Be my guest. That's Morton's rock salt, same stuff you can buy at any hardware store. Been using it for years to keep the ice down. Lost a good ranch hand back in 2012 when he slipped on black ice and broke his hip. Since then, I don't take chances." Patterson walked over, examined the bag, and took a few photos with his phone. "This is just regular de-icing salt. Nothing hazardous about it. I'll file my report and let Mrs. Kimball know that there's no violation here." "I'd appreciate that," I said, thinking that would be the end of it. Though I'm still confused about how she even knew I was salting my driveway. It's not visible from any public road. "Beats me," Patterson said, heading back to his vehicle. "Some people just have too much time on their hands, I guess. Sorry for the trouble, Keith." He drove off, and I went back to my work, spreading salt along the stretch of driveway near the barn. The Double M had been my life's work, built up from the struggling cattle operation my grandfather had left behind. I'd modernized everything, brought in better breeding stock, and even started a small side business boarding horses for folks from Billings who wanted their animals to have more space. The last thing I needed was some busybody from a subdivision I'd never even visited causing problems. But Brenda Kimball wasn't done. 2 days later, I received a certified letter. It was from the Sunset Meadows Homeowners Association, and it was 6 pages long. I sat at my kitchen table, coffee getting cold as I read through the most absurd document I'd ever seen. The letter informed me that I was in violation of 17 different HOA covenants, conditions, and restrictions. According to their records, portions of my property fell within their jurisdiction, and I was required to comply with all regulations immediately. The violations included unsightly agricultural structures, failure to maintain approved landscaping, keeping livestock in a residential area, operating a commercial business without approval, and environmental contamination through the use of rock salt. I had to read it 3 times before the anger set in. These people were claiming they had authority over my ranch that predated their development by at least 70 years. The letter demanded I appear at their next board meeting, scheduled for the following Tuesday at 7 o'clock in the evening, to address these violations and submit a compliance plan. I called my lawyer, Tom Henderson, who'd handled the property transfer when I bought the ranch from my grandfather's estate. Tom had semi-retired since then, mostly playing golf and fishing, but he was still sharp as a tack when it came to property law. "Tom, I need you to look at something for me," I said when he answered. "Some HOA is claiming they have jurisdiction over my ranch." "Which HOA?" "Sunset Meadows. That new development that went up about 5 years ago." There was a long pause on the other end. "Keith, Sunset Meadows is nowhere near your property. They're at least 3 miles south of you." That's what I thought, but they sent me this letter, 6 pages of violations demanding I show up to their board meeting. "Fax it to me. I still have the old machine." "Let me take a look at what they're claiming." I drove into town to the UPS store and faxed the letter to Tom's home office. He called me back within an hour, and his tone had changed from casual to serious. "Keith, you need to come by my office tomorrow morning. Bring every property document you have. The deed, the survey, title, insurance, everything." "What's going on?" "I'm not sure yet, but something doesn't add up. That HOA is making specific claims about property boundaries. Either they're completely delusional, or there's something in the public records we need to check." That night, I barely slept. I kept thinking about my grandfather, how proud he'd been of this land. He'd worked it since the 1960s, raising cattle and horses through droughts, harsh winters, and economic downturns. The ranch was supposed to be my legacy, something to eventually pass down to my own kids someday. The idea that some suburban HOA thought they could tell me what to do with it was infuriating. The next morning, I gathered every document I could find related to the property. The original deed from when my grandfather first purchased the land in 1968. The transfer documents when it passed through my father briefly before coming to me. The survey that had been done in 2010, title insurance papers, and even old property tax records. I loaded everything into a briefcase and drove to Tom's office in downtown Billings. Tom had spread a large survey map across his conference table. He'd clearly been busy that morning, because there were sticky notes and highlighted sections all over it. He looked up when I came in, his expression grim. "Tell me the bad news," I said, setting down my briefcase. "It's complicated," Tom said, gesturing to the map. "When Sunset Meadows was developed 5 years ago, the developers needed to create access roads to their lots. The main county road runs east-west, but their development sits in a valley south of it. Okay, so they needed to build connecting roads from the county road down to their development. Here's where it gets interesting." He pointed to a series of lines on the map. According to the plat map filed with the county, those roads run through what they claimed was an old right-of-way. I leaned in closer, studying the map. "A right-of-way through where?" "Through the northern section of your property." I felt my stomach drop. "That's impossible. I've never granted any right-of-way. The survey from 2010 shows clear boundaries. Nobody asked my permission for anything." Tom nodded. "I know. That's what makes this a problem. I pulled the records from the county clerk's office this morning. When the Sunset Meadows developers filed their plat in 2019, they included a claim that there was a historic right-of-way through your property, dating back to the 1880s. The 1880s. That's before my grandfather even owned it. Exactly. They claimed this right-of-way was established for wagon access between what used to be two separate homesteads. They used this claim to justify building their roads through your northern property line. I pulled out a chair and sat down heavily. So you're telling me there are roads on my property? Not exactly on your property. That's the issue we need to figure out. Either their claim about the historic right-of-way is valid, which means technically those roads are on an easement through your property, or their claim is bogus, which means they've been trespassing and need to tear up their roads. This is insane. I drive past that area all the time. I never saw them building any roads there. Tom flipped through some documents. The construction happened in late 2019. You mentioned you had that bad case of pneumonia that winter and spent 2 months recovering. It was probably while you were laid up. He was right. I'd gotten severely ill in November 2019 and barely left the house until January 2020. I had ranch hands taking care of the daily operations, but I wasn't out checking fence lines or monitoring the northern sections of the property. And the northern section was the least used part of the ranch anyway, mostly just grazing land without much need for regular attention. So what do? I asked. First, we need to verify whether this historic right-of-way actually existed. I'm going to dig through old territorial and county records. If there's no evidence of it, then Sunset Meadows built their roads illegally. Second, we need to get a new survey done immediately to establish exactly where your property lines are versus where their roads actually run. And third, you need to go to that HOA meeting. Why should I go? They have no authority over me. Tom gave me a serious look. Because if their roads are on your property, even partially, and they've been maintaining them for 5 years, they might try to claim adverse possession or prescriptive easement rights. You need to put them on notice immediately that you dispute their claims and do not consent to any use of your property. This is unbelievable. Property law often is, Tom said, but here's what I think happened. The developers were looking for the cheapest way to access their lots. They found some old map, maybe from the 1800s, that showed a trail or wagon path. They made a claim that this constituted a right-of-way, filed it with the county, and built their roads. The county clerk's office probably didn't scrutinize it too carefully because they assumed if there was an objection, the property owner would raise it. But I didn't even know it was happening. That's going to be your strongest argument. You need to show you never received notice, never consented, and never abandoned your property rights. The HOA letter might actually help you there because it shows they're only now trying to assert authority over you, which proves this wasn't some long-standing accepted arrangement. I left Tom's office with a splitting headache and a growing sense of dread. This was going to be expensive and time-consuming, 2 things I couldn't really afford. The ranch operated on tight margins as it was. Cattle prices had been down the past 2 years, and I'd had to take out a loan to replace an aging tractor the previous summer. On Tuesday evening, I drove to the Sunset Meadows Community Center for the HOA meeting. The development was exactly what I expected. Identical 2-story houses with tiny yards, every lawn perfectly manicured, every mailbox the same approved style. It was the complete opposite of ranch life, where function mattered more than form and no 2 buildings looked alike, because they'd been constructed over decades as needed. The community center was a bland beige building with a sign out front listing the rules for its use. I walked in and found about 20 people sitting in rows of folding chairs facing a long table at the front. Behind the table sat 5 people, and I immediately recognized the woman in the center as Brenda Kimball from the photo on the HOA website I'd looked up earlier. Brenda was exactly what I'd pictured. Mid-40s, blonde hair in a severe bob, wearing a blazer that looked too formal for a neighborhood meeting. She had papers spread in front of her and was speaking to the gathered residents about parking violations. I took a seat in the back and waited. The meeting dragged through various mundane issues. Someone had planted the wrong type of bush. Someone else had left their trash cans visible from the street on a non-collection day. A request to install a basketball hoop was denied because it would create noise pollution. Finally, after 45 minutes of this nonsense, Brenda looked at her agenda and said, "Next item. The property violation at 14,000 Ranch Road." That was my address. "Is the property owner present?" she asked, scanning the room. I stood up. "I'm Keith Morrison. I own the Double M Ranch." Brenda's eyes lit up like she'd been waiting for this moment. "Mr. Morrison, thank you for attending. We've sent you multiple notices about the violations on your property." "I received one letter, dated last week," I said calmly. "And before we go any further, I want to state for the record that I dispute any claim that my property is subject to this HOA's jurisdiction." A murmur went through the crowd. Brenda's smile turned icy. "Mr. Morrison, Sunset Meadows has clear authority over all properties within our established boundaries, as filed with Yellowstone County. Your property includes parcels that fall within those boundaries, specifically the areas adjacent to Meadowbrook Drive and Sunset Circle." "Those are roads on my land," I said, keeping my voice level. "Roads that were built without my knowledge or permission." "The roads were built on a legally established right-of-way," Brenda shot back. "A right-of-way that has existed since the 1880s. When you purchased your property, you purchased it subject to that easement. I'd like to see documentation of this supposed right-of-way." Brenda shuffled through her papers. "The plat map filed by Sunset Meadows Development Corporation clearly shows the historic easement." "A plat map filed by the developer is not proof that the easement actually existed," I said. "I'm going to need to see original source documents from the 1880s establishing this right-of-way, proof that it was properly recorded, and evidence that it was never abandoned." The man sitting to Brenda's left, who wore a name tag identifying him as Gerald, the HOA vice president, leaned forward. "Mr. Morrison, I think you're misunderstanding the situation. The roads are built. Homeowners in this community rely on them for access to their properties. Whether or not you like it, those roads are staying. If those roads are on my property and were built without valid legal authority, then they're coming out," I said. "This isn't a negotiation." Brenda stood up, her face flushing red. "Mr. Morrison, you are being extremely unreasonable. This HOA has invested hundreds of thousands of dollars in infrastructure based on properly filed legal documents. You cannot simply demand that we tear up our roads. Then you should have made sure you actually had the right to build them in the first place." "We did have the right." Brenda's voice was rising. "The county approved everything. The plat was recorded. Everything was done properly." "Except for the part where nobody asked the actual landowner," I said. A woman in the third row raised her hand. "Excuse me, but if the roads go through his property, doesn't that mean he could block them? My house is on Sunset Circle. That's my only way in and out." Panic flickered across several faces in the room. I saw people pulling out their phones, probably pulling up maps to figure out which roads might be affected. Brenda tried to regain control. "Nobody is blocking any roads. Mr. Morrison is simply confused about property boundaries. Once he reviews the proper documents, this will all be cleared up. I've reviewed my deed, my survey, and my title insurance, I said. I've also hired an attorney. We'll be conducting a new survey to establish the exact boundaries, and we'll be researching the claimed historic easement. Until this is resolved, I'm putting this HOA on formal notice that I do not consent to any use of my property, and I do not acknowledge any authority by this HOA over my land. You can't do that, Gerald said, standing up. People live here. They need access to their homes. Then you should have thought about that before building on someone else's property. Brenda pointed a finger at me. Mr. Morrison, if you interfere with our roads, we will take legal action. We will sue you for every penny you have. We will file injunctions. We will seek damages, and we will make sure that you pay for any harm caused to our community. You do what you need to do, I said. I'll be doing the same. I walked out of the community center to the sound of erupting arguments behind me. People were yelling at Brenda, demanding to know how this could happen. Others were shouting that I was being unreasonable and selfish. I didn't care. This was my land, worked by my family for decades, and some suburban development didn't get to just take it because it was convenient. The next morning, Tom called with an update. I've been through the territorial records at the state archives. There's no documentation of any right-of-way through your property from the 1880s. No wagon road, no trail easement, nothing. So they made it up. It looks that way. I found the map they probably used as their source. It was a hand-drawn sketch from 1887 that shows some trails in the general area, but it's not an official survey and it doesn't match up with actual property lines. They took a very rough historical map and claimed it established a formal easement. Can we use that? Absolutely. I'm drafting a formal legal challenge, but Keith, there's something else. I drove out to Sunset Meadows this morning to look at those roads myself. And it's worse than I thought. Meadowbrook Drive and Sunset Circle aren't just running along your property line. They cut straight through your land. Based on your 2010 survey, which I trust more than their plat map, those roads occupy approximately 11 acres of your property. I felt the anger building again. 11 acres, give or take. We'll know exactly once we get the new survey done. I've got a surveyor coming out next week. But Keith, 11 acres at current land values in that area, we're talking about maybe $150,000 worth of your property that they've paved over. So, what happens now? Now it gets complicated. They're going to argue that even if the original easement claim was faulty, they've invested substantial money in good faith based on county-approved plans. They'll try to claim some kind of equitable easement or argue that you're stopped from challenging it now. In English, Tom. They're going to say that even though they screwed up, it would be unfair to make them fix it now because it would cost too much money and hurt the homeowners. It's a weak argument, but judges sometimes go for it to avoid what they see as a harsh result. A harsh result. What about what they did to me? I know. I'm just telling you how they'll play it. We need to be strategic here. First, we establish definitively that the roads are on your property and that there was never a valid easement. Second, we show that you had no notice and no opportunity to object when they were built. Third, we demonstrate that allowing them to keep the roads would harm your use and enjoyment of your property. It's ranch land, Tom. I need every acre for grazing. Those roads cut through pasture that I lease out. Good. That's economic harm we can quantify. How much do you make from that pasture? I lease it to a neighbor for his cattle. He pays me about $5,000 a year for that section. So you've already lost $25,000 in lease payments over 5 years, plus the property value. We can work with that. Tom told me he'd have the legal papers filed within a week. In the meantime, I had a ranch to run, but the situation with Sunset Meadows kept gnawing at me. I decided to drive up to the northern section of my property and actually look at these roads I'd apparently been sharing with an entire subdivision. I took the ranch truck up the dirt road that ran through my property toward the northern fence line. As I got closer, I could see where the landscape changed. What had been rough grazing land with natural grass and scattered trees suddenly gave way to smooth asphalt. Two roads, Meadowbrook Drive and Sunset Circle, curved through what should have been my pasture. They were proper residential streets, complete with curbs, sidewalks, and street signs. I parked the truck and got out, walking along the edge of where my land met their asphalt. There was no fence, no marker, nothing to indicate this was supposed to be a boundary. They just paved right through as if the land was theirs. Looking down Sunset Circle, I could see about 8 houses that backed up to what they probably thought was common HOA land but was actually my property. The more I looked, the angrier I got. They'd put in decorative lamp posts along the roads. There was a storm drain system. They'd even planted trees in what they designated as a median strip. All of this on my land, without asking, without paying, without any acknowledgement that this was someone else's property. I pulled out my phone and started taking pictures. I photographed the roads from every angle, the street signs, the houses visible from where I stood. I walked the approximate line where I knew my property boundary should be based on the old survey, taking GPS coordinates on my phone. The roads didn't just barely cross onto my land. They were well into my property, easily 50 to 60 feet past where the boundary line should have been. As I was documenting everything, a car pulled up on Sunset Circle. A man in his 30s got out, looking at me suspiciously. "Can I help you?" "Just checking my property," I said. "Your property? This is HOA land." "No, it's not. This is part of the Double M Ranch. Those roads are on my land." His face went pale. "You're that guy, the one from the meeting, Keith Morrison. I own 1,200 acres here, including the land under your roads." "That's impossible. We bought our house 2 years ago. The disclosure statement said the HOA owned and maintained all common areas." "The HOA doesn't own this land." "I do. They built here without permission." "But we need these roads. My house is on Sunset Circle. If this road goes away, I have no access." "That's between you and the HOA," I said. "I didn't create this problem." He got back in his car and sped off, presumably to call Brenda or his lawyer or both. I finished my documentation and headed back to the ranch house. I had a feeling things were about to escalate. I was right. The next morning, I found a truck from the Sunset Meadows HOA parked at the entrance to my property. 2 men were installing a chain across the dirt road that led from the county road onto my land. I drove up and rolled down my window. "What are you doing?" One of the men, wearing a Sunset Meadows polo shirt, said. "HOA business. We're securing our property." "That's not your property." "That's my ranch entrance. According to the HOA, this access point crosses our roads and you need permission to use it." I couldn't believe what I was hearing. "You're blocking access to my ranch. We're securing HOA property. If you have a dispute, you can take it up with the board." I pulled out my phone and called Tom. "They're blocking my ranch entrance." "Don't confront them. Call the sheriff." I dialed 911 and explained the situation. 20 minutes later, a sheriff's deputy arrived. This time it was an older officer named Martinez who I'd known for years. "Keith, what's going on?" I explained the whole situation, the HOA's claims, the roads on my property, and now the chain blocking my entrance. Martinez walked over to examine the chain, then came back to me. "This is private property dispute." I can't order them to remove the chain without a court order. But this is my property. They're blocking legal access to my ranch. You have documentation proving this is your land. I pulled out my deed from the truck's glove compartment. Martinez looked it over, then went to talk to the HOA workers. They showed him something on a tablet. He came back looking frustrated. They've got a plat map showing this as HOA property. You've got a deed showing it as your property. This is above my pay grade. You need to get a judge to sort this out. In the meantime, I can't access my ranch. Is there another way in? There's a back road, but it adds 15 miles and goes through private land I'd need permission to cross. Martinez sighed. Look, my advice is to use the back road for now and get your lawyer to file for an emergency injunction. If you try to remove that chain yourself, they could claim you're destroying their property, and then I'd have to deal with that. It was the most frustrating non-answer possible, but I understood his position. I called Tom again and explained what happened. They've really escalated this, Tom said. That's actually good for us. It shows they're acting aggressively and unreasonably. I'll file for an emergency hearing today. We should be able to get in front of a judge by tomorrow or Friday. What do I do about the ranch? I've got cattle that need to be checked, equipment that needs to be moved. Use the back road. Document everything. Take pictures of the chain, the workers, everything. This is going to help our case. I spent that day taking the long route around to access my own property, seething the entire time. The back road Tom mentioned required driving an extra 15 miles and going through a neighbor's land. Luckily, my neighbor Chuck was understanding when I called him, but it was humiliating to have to ask permission to access my own ranch. Tom moved fast. By Wednesday afternoon, we were in front of Judge Patricia Wells in Yellowstone County District Court. The HOA had hired a lawyer too, a slick-looking guy named Richard Pruitt, who specialized in real estate law. Judge Wells was in her 60s, with a reputation for being fair but no nonsense. She listened as Tom explained the situation, showing her my deed, the 2010 survey, and the lack of any historical documentation for the claimed easement. Pruitt countered with the HOA's plat map, the county's approval of the development, and an argument that the roads had been used openly and continuously for 5 years, without objection from me. Your Honor, Pruitt said smoothly, Mr. Morrison had ample opportunity to object to these roads when they were being constructed. He chose not to do so. Now, 5 years later, after 300 families have purchased homes relying on these roads for access, he wants to append an entire community. This is a clear case of lashes and estoppel. That's nonsense, Tom countered. Mr. Morrison was seriously ill during the construction period and had no knowledge of what was happening. The moment he learned about the HOA's claims, he objected. There's no lashes when someone doesn't know their rights are being violated. Judge Wells held up a hand. Let's address the immediate issue first. Mr. Henderson, you're asking for an injunction requiring the HOA to remove the chain blocking your client's property access. Yes, Your Honor. They've blocked the primary access to his ranch, forcing him to take a route that's 15 miles longer and crosses other private property. Mr. Pruitt, why did your client block Mr. Morrison's access? Pruitt hesitated for just a moment. Your Honor, the HOA was concerned about Mr. Morrison using their roads without authorization. He's been driving across Meadowbrook Drive to access his property, and given his statements at the HOA meeting, they were concerned he might damage the roads in retaliation. Has he damaged any roads? Judge Wells asked. Not yet, but not yet. So you blocked his property access based on something he might do. We were exercising our rights to control access to HOA property, Your Honor. Judge Wells looked at the maps spread on her desk. Here's my problem, Mr. Pruitt. Even if we accept your client's position that there's a valid easement through Mr. Morrison's property for those roads, that doesn't give them the right to block his access to his own land. An easement is a limited right to use someone else's property for a specific purpose. It doesn't transfer ownership. Your Honor, we're not claiming ownership. Then you had no right to block access. Here's what's going to happen. I'm issuing a temporary order requiring the HOA to remove that chain immediately. Mr. Morrison will have full access to his property. As for the larger question of whether those roads are legally on his property, we're going to need a full hearing with expert testimony. I'm scheduling that for 6 weeks from now. In the meantime, Mr. Pruitt, your clients are not to interfere with Mr. Morrison's use of his property in any way. Am I clear? Yes, Your Honor, but I must note that the HOA has concerns about. Your concerns are noted. Remove the chain. We'll sort out the rest at the full hearing. We left the courthouse with a small victory. The chain came down that afternoon and I had my access back. But the real battle was just beginning. Over the next 6 weeks, both sides prepared for the hearing. Tom hired a surveyor who confirmed that Meadowbrook Drive and Sunset Circle were indeed on my property, crossing about 11 acres total. We found historical records showing that my property had been continuously owned and used for ranching since 1968, with clear surveys establishing the boundaries. Most importantly, we proved there was no historic easement or right-of-way from the 1880s. The map the developers had relied on was a general sketch that wasn't tied to any specific property lines. The HOA brought in their own experts who tried to argue that even if the original easement claim was wrong, the roads should stay, because removing them would be too disruptive. They claimed it would cost over $2 million to relocate the roads, and that some of the houses would lose value or access entirely. The full hearing took 3 days. Brenda Kimball testified about how the HOA had relied on the county's approval and the developer's plat map. She tried to paint me as an unreasonable neighbor trying to destroy a community over a technicality. When it was my turn to testify, Tom asked me to explain what the ranch meant to me and my family. I talked about my grandfather working this land for decades, about building up the cattle operation, about my plans to eventually pass it down to future generations. I explained that the 11 acres taken by their roads was prime grazing land that I'd been leasing out for income, and that the roads had cost me tens of thousands of dollars in lost revenue. Tom also established that I'd received no notice of the development, no opportunity to object, and no compensation. The developer hadn't even tried to contact me, just filed their plat map with the county and started building. On the 3rd day, Judge Wells announced her decision. This is a difficult case because we have innocent parties on both sides. Mr. Morrison had his land taken without notice or compensation. The homeowners in Sunset Meadows bought their properties in good faith, believing the roads were legitimate. However, under the law, the answer is clear. There was no valid historic easement. The developer's plat map was based on faulty research and wishful thinking. Mr. Morrison owns the land under those roads, and he never consented to their construction. Brenda's face went white. Several homeowners in the gallery gasped. Judge Wells continued. The HOA's arguments about estoppel and lashes fail because Mr. Morrison had no knowledge of the construction when it occurred and objected immediately upon learning of it. As for the argument that removing the roads would be too costly or disruptive, that's not Mr. Morrison's problem. The HOA and the developer created this situation through their failure to properly verify property rights. Mr. Morrison should not be forced to give up his land because fixing the HOA's mistake would be expensive. However, the judge said, and I felt my stomach tighten, I'm not going to order the immediate removal of the roads. That would create an emergency situation for the families living there. Instead, I'm giving the HOA 12 months to relocate the roads to property they actually own or have legal rights to use. During that time, they will pay Mr. Morrison fair market rent for the use of his property, calculated as the value of 11 acres plus damages for lost use. If they fail to relocate the roads within 12 months, Mr. Morrison will have the right to remove the roads himself and bill the costs to the HOA. She set the rental amount at $8,000 per month, which seemed fair given the property values in the area. She also awarded me $75,000 in damages for the 5 years of lost use and the costs of my legal fees. Brenda stood up, her voice shaking. Your Honor, the HOA doesn't have the funds for this. Our reserves are only about $50,000. Then you'll need to levy a special assessment on your members or find some other source of funding. This court's job is to remedy the wrong done to Mr. Morrison, not to ensure the HOA's financial comfort. We walked out of the courthouse victorious, but I didn't feel like celebrating. Tom was thrilled with the outcome, calling it a complete win. But I knew the fight wasn't really over. Over the next few weeks, the situation in Sunset Meadows devolved into chaos. The HOA sent out letters to all homeowners announcing a special assessment of $6,000 per household to cover the costs of relocating the roads and paying me. The homeowners revolted. They packed the next HOA meeting, demanding to know how this had happened and who was responsible. Brenda tried to defend herself, claiming she'd just been following the developer's documentation, but the homeowners weren't buying it. They'd elected her to protect their interests, and instead she'd gotten them into a legal nightmare. Someone found out that Brenda had been warned by another board member 2 years earlier that the roads might be on someone else's property, but she dismissed the concern without investigating. That revelation led to calls for her resignation. The drama intensified when several homeowners filed a lawsuit against the developer, Sunset Meadows Development Corporation, claiming fraud and breach of warranty. They argued that the developer had sold them houses with false promises about the roads and access. The developer's response was to declare bankruptcy, claiming they had no assets left to pay any judgments. With the developer bankrupt and the HOA in turmoil, I started receiving phone calls from desperate homeowners. Some were angry, calling me selfish and threatening to make my life difficult. Others were pleading, asking if there was any way we could work something out that didn't require them to pay $6,000 they didn't have. One call in particular stuck with me. It was from a young woman named Sarah who lived on Sunset Circle with her husband and 2 small kids. She was crying as she explained that they'd used all their savings for the down payment on their house. They didn't have $6,000 for the special assessment, and they couldn't afford to sell and move because they'd lose money on the house. "Please, Mr. Morrison," she sobbed. "We didn't do anything wrong. We just wanted a home for our kids. I don't know what we're going to do." I felt terrible for her and families like hers, but I also couldn't just give away my property rights. Tom had warned me that any gesture of sympathy could be used against me, that the HOA would try to claim I'd waived my rights or created some kind of informal agreement. As the weeks passed, the HOA failed to make any progress on relocating the roads. They hired an engineer who determined it would actually cost closer to $3 million, not $2 million, to build new roads on property the HOA actually owned. The terrain wasn't suitable in most places, and they'd need to blast through rock and build retaining walls. Some homeowners would still end up landlocked even with new roads. 3 months after the judge's decision, Brender resigned as HOA president. The board appointed Gerald as interim president, but he quickly realized the situation was impossible. The HOA simply didn't have the money to relocate the roads, and most homeowners couldn't afford the special assessment. Gerald called me and asked if we could meet. We met at a coffee shop in Billings, and he looked exhausted. "Mr. Morrison, I'm going to be straight with you. We can't afford to relocate those roads. We can't even afford to keep paying you $8,000 a month for rent. The HOA is going to run out of money in about 2 months." "That's not my problem," I said, though I felt bad saying it. "I know. And legally, you're completely in the right. But I'm asking you, person to person, is there any way we can work something out? Some kind of compromise? Like what? Could we negotiate an easement? Pay you a one-time fee for the right to keep the roads where they are?" I'd been thinking about this possibility. "How much are we talking about?" "The 11 acres are worth about $150,000. Could we pay you that amount, plus your legal fees, and you grant us a permanent easement? That doesn't account for lost use of the land. I was leasing it for income." Gerald nodded. "What if we made it $200,000? That's more than the land value and covers lost income." "Where would you get $200,000? We'd have to get a loan. Put a lien on the common areas we actually own. It would still be cheaper than trying to relocate the roads." I told Gerald I'd think about it and talk to Tom. When I explained the offer to my lawyer, he was skeptical. "Keith, you don't have to settle. You've won. The judge gave you the right to remove the roads if they can't fix this." "I know, but Tom, I met some of these people. They're just families who bought houses. They didn't create this mess. Your grandfather spent his whole life building up that ranch. Are you really willing to give away 11 acres because you feel sorry for people who didn't do their due diligence before buying?" He had a point. But I kept thinking about Sarah and her kids, and about the dozens of other families who were going to be financially destroyed by this. I thought about what my grandfather would do. He'd been a hard man in many ways, but he'd also been fair. He'd always said that being right wasn't enough. You had to be just. After a week of thinking, I called Gerald back. "Here's my counteroffer. $250,000, paid within 90 days. In exchange, I'll grant a permanent easement for the existing roads and agree not to seek any additional damages. The easement will include specific terms about maintenance, liability, and what happens if the HOA dissolves." Gerald was quiet for a moment. "That's more than we offered. It's less than relocating the roads would cost, and less than what you'd owe me if we kept going with the monthly rent plus legal battles. This ends it. Clean break. Let me talk to the board." 2 days later, Gerald called back. They'd accepted the offer. The HOA would take out a loan secured by their actual common property, pay me the $250,000, and I'd grant the easement. Tom drew up an agreement that was very specific about the terms. The HOA would be responsible for all maintenance and liability for the roads. If the HOA ever dissolved, the easement would transfer to a homeowners maintenance association. I retained the right to access the land around the roads and could not be held liable for any damage to the roads caused by my legitimate ranch operations in adjacent areas. We closed the deal 92 days after my counteroffer, 3 days before the deadline. The HOA wired $250,000 to my account, and I signed the easement agreement. Judge Wells approved the settlement, and the case was officially closed. With the settlement money, I was able to pay off the loan on my tractor, build a new barn I'd been putting off, and put a substantial amount into savings. More importantly, I'd established clear property boundaries and protected my rights for the future. But the story doesn't quite end there. About a month after the settlement, I received a call from the Yellowstone County Sheriff's Office. It was Detective Lisa Chen, and she wanted to talk to me about the Sunset Meadows development. "Mr. Morrison, we've been investigating some irregularities in how that development was approved and platted. Your case raised some red flags, and we've been digging deeper. Can you come in and answer some questions?" I met with Detective Chen the next day. She explained that my lawsuit had exposed what appeared to be a pattern of fraudulent property claims by Sunset Meadows Development Corporation. We found 3 other properties where the developer claimed historic easements or rights of way that didn't actually exist, Chen explained. In one case, they built a drainage system under someone's land without permission. In another, they claimed access rights through a property that turned out to be a designated wetland. They've been cutting corners and fabricating legal justifications all over the place. What happens now? We're building a criminal case for fraud and filing false documents. The developer is already bankrupt, but there are individual people who made these decisions. We're looking at the CEO and the company's surveyor, who signed off on plat maps he apparently never actually verified. Over the next few months, the criminal case developed. The developer's CEO, a man named Marcus Webb, was indicted on multiple counts of fraud and making false statements on official documents. The surveyor, David Chen, no relation to the detective, was charged as well for signing surveys he'd never actually performed. The case went to trial in early 2025. I was called as a witness to explain what had happened with my property. Prosecutors showed that Webb had a pattern of finding old, vague historical maps and claiming they established rights his company didn't actually have. He'd done this to save money on land acquisition and to make development cheaper. The surveyor had been complicit, signing off on plat maps without doing proper boundary verification, because Webb paid him to rubber stamp everything. The trial lasted 2 weeks. In the end, Marcus Webb was convicted on multiple counts and sentenced to 4 years in federal prison plus restitution. The surveyor got 2 years and lost his professional license permanently. Brenda Kimball, the former HOA president, faced civil consequences but no criminal charges. Several homeowners sued her for negligence in her role as HOA president, claiming she should have verified the property rights before enforcing rules against me. Those cases settled out of court, with Brenda's homeowners' insurance paying out about $30,000 total to the plaintiffs. As for me, life got back to normal. The Double M Ranch continued operating as it had for decades. I could drive past Sunset Meadows now and see those roads crossing through my northern property without feeling the anger I'd felt before. The situation wasn't ideal, but the easement agreement was fair, and I'd been compensated appropriately. The homeowners in Sunset Meadows eventually settled into their new reality. The special assessment to pay for the easement cost each household about $2,000 after the loan was factored in, much less than the original $6,000 they'd been facing. Gerald turned out to be a decent HOA president, much more reasonable than Brenda had been. He actually invited me to speak at an HOA meeting about 6 months after the settlement to clear the air. I stood in front of the same community center where Brenda had once threatened to sue me for everything I had. The crowd was different now, more curious than hostile. I explained my side of the story, emphasized that I'd never wanted to hurt anyone, and noted that I'd accepted a settlement that was far less than what I could have demanded. I grew up on ranches, I told them. My grandfather taught me that land is more than just property. It's legacy, it's history, its identity. When your HOA tried to claim authority over my ranch, it wasn't just about acres or money. It was about respecting what my family built over generations. I'm glad we found a solution that works for everyone. The applause was genuine, and several people came up afterward to shake my hand and apologize for the things that had been said during the heat of the conflict. Sarah, the young mother who'd called me crying, approached with her kids. Her eyes were red. "Thank you for settling," she said. "I know you didn't have to. My husband and I were ready to lose our house. The settlement saved us." "I'm glad it worked out," I said, meaning it. Gerald and I actually became friendly after that. He'd invite me to HOA events occasionally, and I'd show up when I had time. Some of the homeowners became curious about ranch life, and I ended up giving tours of the Double M to a few families. Their kids loved seeing the cattle and horses, and I enjoyed sharing the heritage of the land. The criminal convictions of Webb and the surveyor sent shockwaves through the development industry in Montana. The county clerk's office implemented new procedures for verifying property claims on plat maps. They now required independent verification of any claimed easements or rights of way before approving developments. Several other questionable developments were put on hold pending investigation. Tom retired for real after our case, proud to go out on a victory. He'd handled the matter mostly as a favor to me, charging reduced rates because we'd been friends for years. At his retirement party, he told everyone that the Sunset Meadows case reminded him why he'd gone into law in the first place. "It's easy to think property law is boring," Tom said, slightly drunk on champagne. "Just deeds and surveys and dusty old documents. But behind every property dispute is someone's home, someone's livelihood, someone's future." Keith's case mattered because it was about respecting rights and finding justice. I'm proud of the work we did. I raised a glass to him, grateful for everything he'd done. Without Tom's expertise and dedication, I might have lost those 11 acres permanently. The ranch might have been slowly carved up by adverse possession and prescriptive easements, until there was nothing left of what my grandfather built. Looking back on the whole ordeal, from that first visit by Officer Patterson about the salt on my driveway to the final settlement signing, I learned a lot about the importance of knowing your property rights and standing up for them. I also learned that sometimes the right answer isn't just about winning. The satisfaction of removing those roads would have been nothing compared to the guilt I'd have felt watching families lose their homes over something that wasn't really their fault. The $250,000 settlement was fair compensation, maybe even generous by some standards, but it preserved my property rights while allowing people to keep their homes. It ended a conflict that could have dragged on for years in appeals and countersuits. Most importantly, it let me sleep at night knowing I'd done the right thing, not just the legally permissible thing. My grandfather used to say that land teaches you lessons if you pay attention. The lesson from the Sunset Meadows situation was about balance. About standing firm when you're right, but being flexible enough to find solutions that work for everyone. About understanding that legal rights come with moral responsibilities. About recognizing that sometimes the people on the other side of a dispute are victims of the same bad actor that victimized you. Today, I still ranch the Double MTK's 1,200 acres. When I drive up to check on the northern pastures, I take the access road that crosses over Meadowbrook Drive and Sunset Circle. Those roads are maintained by the HOA under our easement agreement, always in good condition. Sometimes I see kids playing in yards along Sunset Circle, or families walking their dogs along Meadowbrook Drive. They're living their lives, building their own memories on land that's been in my family for generations. It's not how I would have designed things, but life rarely is. The important thing is that my property rights are protected, my ranch continues to operate, and I can look anyone in the eye knowing I acted with integrity throughout the whole mess. My grandfather would have approved, I think. He was always more interested in doing things right than doing things easy. The cattle don't care about easements or HOA disputes. They just want good grass and clean water, which the Double M continues to provide. The horses I board for city folks don't worry about property lines. They're content with open space and regular feeding. And me, I learned that sometimes defending your rights means knowing when to compromise, and that winning a battle isn't always about crushing your opponent. Brenda Kimball's aggressive approach to the HOA, calling the cops over salt on my driveway, and trying to assert authority she didn't have, ultimately backfired spectacularly. If she'd approached the situation differently, maybe done some actual research before making threats, things might have turned out better for everyone. But her assumption that she could bully a rancher into compliance because she had an HOA title and a copy of the covenants showed a fundamental misunderstanding of how property rights actually work. The real villains in this story were Marcus Webb and David Chen, the developer and surveyor who knowingly filed false documents and built on land they had no right to use. Their criminal convictions brought some measure of justice, though it didn't undo the chaos they'd caused. The 4 years Webb got in federal prison, and the restitution he owes won't come close to compensating all the people harmed by his fraud. But at least the system worked eventually, even if it took my lawsuit to expose the problems. As for the Sunset Meadows HOA, they're under new management now. Gerald served as president for 2 years before stepping down, replaced by a retired accountant who runs things much more carefully. They check everything, verify everything, and never assume they have authority without clear documentation. The experience taught that community a valuable lesson about due diligence. I still spread salt on my driveway every winter when the ice comes. Nobody calls the cops anymore. In fact, Gerald asked me last year if I could recommend a good de-icing product for the HOA roads, since they're responsible for maintaining them under our easement. I told him about Morton's rock salt, same stuff I use, available at any hardware store. He laughed and said he appreciated the irony. The Double M Ranch will continue long after I'm gone. I'm working on succession planning now, thinking about whether to pass it to a nephew who's shown interest in ranching or maybe sell it to another ranching family who will maintain the heritage. Whoever ends up with it will have clear property boundaries, protected rights, and that easement agreement ensuring the Sunset Meadows roads stay where they are without causing future problems. Sometimes on quiet evenings, I drive up to the northern section and park where I can see both the ranch land and the subdivision. It's a strange border where rural Montana meets suburban America. 2 different worlds, 2 different ways of life, coexisting on land that has its own story stretching back long before any of us arrived. The ranch was here before Sunset Meadows, and it'll be here after those houses are gone and replaced with whatever comes next. That's the thing about land. It outlasts all our disputes and dramas. The property lines we draw, the documents we file, the legal battles we fight, they're all just temporary marks on something permanent. My job as a rancher, as someone entrusted with this land, is to protect it and use it wisely for as long as it's mine. That meant standing up to the HOA when they tried to take what wasn't theirs, but it also meant finding a solution that preserved the land's integrity without destroying people's lives. I think I got it right, mostly. The $250,000 sits in the bank, earning interest and providing security for the ranch's future. The easement agreement protects my rights while acknowledging reality. The criminal prosecutions held the real wrongdoers accountable. And life goes on, here on the Double M Ranch, where it always has and hopefully always will. Some folks in town still talk about the case, usually when property disputes come up or when someone mentions HOAs. I've become a bit of a local legend, the rancher who stood up to an HOA and won. People buy me drinks at the bar and ask for advice about their own property issues. I'm always happy to help, usually with the same advice Tom gave me. Know your rights, document everything, and don't back down when you're right. But I also tell them the rest of it, the part that doesn't make for dramatic bar stories, about how being right isn't enough if you want to live with yourself afterward, about how compromise isn't weakness when it's done from a position of strength, about how sometimes the best victory is one where everyone walks away able to move forward. The salt on my driveway that started this whole mess still gets spread every winter. It's such a small thing, rock salt on ice, but it led to discovering that an entire subdivision had built roads through my property. Life is funny that way. Small things reveal big problems, and sometimes dealing with those problems teaches you more about yourself than you expected to learn. I'm Keith Morrison, owner of the Double M Ranch, and I've got about 1,200 acres of Montana ranchland that's mine, clear and undisputed. Well, except for those 2 roads running through the northern section. But that's covered by a properly executed easement agreement that pays me $250,000 and preserves my rights forever. All because an HOA president named Brenda didn't like salt on my driveway and assumed she had authority she never actually possessed. Sometimes I wonder what would have happened if Officer Patterson hadn't been reasonable that first day, if he'd sided with Brenda and tried to cite me for spreading hazardous materials. Would I have fought back then, or would I have shrugged it off and let the issue slide? I'd like to think I'd have stood up for myself regardless, but you never know until you're tested. The test came, and I passed it. The ranch survived, stronger than before with documented boundaries and clear rights. The families in Sunset Meadows kept their homes and learned to be more careful about who they trust with their HOA governance. Justice was served to the people who actually committed crimes. And me. I got a story that'll be told around here for years, maybe decades, about the time an HOA called the cops over driveway salt and ended up owing a rancher $250,000. Not a bad outcome, all things considered.